Oh, terrific. All right, thank you for being here with us tonight. I'm here with Judge Oscar Petite, and I'm going to give you a little introduction about what we're about and what we're going to be talking about tonight. Pennsylvanians for Modern Courts is a nonpartisan nonprofit. We envision a Pennsylvania that is in which everyone is assured impartiality, accessibility, and respect. For over 35 years, PMC has worked to educate all Pennsylvanians about the courts and how to navigate them with confidence. While we are not offering legal advice today, we hope this presentation is informative and educational to you all. On behalf of PMC, thank you so much for joining us tonight, and thank you to the Carnegie Public Library and the Allegheny County Law Library for hosting us. After the event is over, you'll be receiving a recording of this program. You probably heard the recording announcement, as well as a questionnaire. Filling out the questionnaire helps us bring you more workshops like this one. And let me just make sure we get our slides going. So this is a rundown of what I just read to you. I also wanted to mention some of our upcoming programming across the state. We are based in Philadelphia, but I am the Pittsburgh program coordinator, and I'm happy to be here. We have a few events coming up in Pittsburgh, including at the end of the month, we'll be at the Homewood YMCA, and then back here at the library in April on the 16th. Now, as for the main event, Judge Oscar Petite is a Hill District native and lifelong resident, as well as a graduate of both CMU and Duquesne Law. He has served as a magisterial district judge since 1995, representing the Hill District, Uptown, Downtown, and the Strip District. And I'll hand it over to you now, Judge Petite.
Good evening. Okay, I'm Judge Oscar Petite. I'll be presiding over today's landlord and tenant workshop. This is the fun part of my day. You know, being in court all day and then getting a chance to spend with you all is just something that works out for me very well. We're going to talk about landlord-tenant law and landlord and tenant disputes, and I can bring to you some firsthand experience from my court. And we're going to go through this outline that we have here, and some of the things I'll go over very fast. We're going to be 1 hour. I'm going to try to wrap this up in about 45 minutes so we can have 15 minutes left for questions. But let's talk about the hierarchy of the Pennsylvania court system. At the top is the Pennsylvania Supreme Court. That court was established in 1722. It is the oldest court in the land. As a matter of fact, that court is older than the U.S. Supreme Court. After that, we have our intermediate level of appellate courts. They are the Commonwealth Court and the Superior Court. The Commonwealth Court hears issues involving government entities, whereas the Superior Court hears all other matters that are not involving government entities. The Court of Common Pleas is our general trial court. Issues involving criminal cases and civil cases are heard in that court. The appeals from that court go to Commonwealth Court or Superior Court, depending on who the body is that is being sued. And below that, which is at the bottom, the municipal courts and the magisterial district courts. That is the level that I am on. If anyone is ever going to have a court experience, more than likely it will be at that level. So Allegheny County Court of Common Pleas, the division heads are the Civil Division, the Honorable Alan Hertzberg, Criminal Division, the Honorable Bruce Beamer, Family Division, the Honorable Catherine Hans Greco, and an orphans court is, there's an administrative judge there. And our president judge is Judge Susan Ivashevic de Lucente. As I mentioned, the Superior Court and the Commonwealth Court and the Common Pleas Court, those jurisdictions, first of all, the Pennsylvania Supreme Court is the ultimate authority on matters brought before the lower courts. Review is discretionary in many cases, so everything does not get to the Pennsylvania Supreme Court. The Pennsylvania Supreme Court has supervisory activities over the Administrative Office of Pennsylvania Courts, the education of judges, which, like myself, the Judicial Conduct Board, etc. Landlord and tenant rights and responsibilities. Let's talk about that. Okay, renting a, I'm gonna go back here. Renting a house or apartment is one of the most significant decisions that you can make. I'm going to go back here because there was a couple of slides that got skipped and I think I needed to talk about them. One thing you can't do when renting a house is be discriminated against. What are examples of discrimination? The landlord says that the rent is higher than advertised after the meeting. The potential tenant in person or falsely denying that a unit is available for rent. Or you go to rent to see the unit and all of a sudden they tell you that the unit is not available because they don't like the way you look. The landlord does not allow full use of all home facilities or requires you to live in a certain part of the building. And an advertisement states that a property is only available to people without children. Refusing to permit a person with disabilities to make reasonable modifications to the unit and retaliating against you for opposing housing discrimination or for filing a complaint about discrimination. What are tenants' rights? The implied warranty of habitability. The rental unit must be in a fit and habitable condition. What does that mean? You can't have sewage backup. You can't have a unit where the windows don't work. You can't have a unit where the electrical sockets are not working. Those would be violations of the warranty of habitability. The implied now, if you hold your question, write it down and hold your question, and I guarantee you I'll come back to that question. The implied covenant of quiet enjoyment is not just noise. It's the right to use and enjoy the rental unit without reasonable interference by the landlord. In other words, the landlord can't be stopping by your house every week saying, I want to inspect, or even once a month. That would probably be unreasonable. It's not noise coming out of your unit. It's interfering with the peaceful and quiet enjoyment of your unit. The right to exclusive possession of the residence, expectation of privacy, and unlimited access to the property. The landlord can inspect the property with notice and can enter in emergencies. So what does that mean? All right, the landlord should be giving you 48 hours notice before they come into your unit. Well, let's suppose the landlord lives close by and they drive by your place and you're not home and water's coming out your front door. They have a right to go up in there and deal with that issue. That would be an emergency situation. But any other situation, the landlord should give you 48 hours notice. They should let you know exactly what time they arrived in your unit and what time they left. All right, start moving to the next slide. Or I can just do it from that. Okay. All right, good. I got my backup here. So what are the tenant's responsibilities? A tenant's main responsibility is to pay the rent and to pay it on time. Most leases say that the rent is due on the 1st and late by the 5th of the month. They must also obey the terms of the lease. If the lease states that the tenant must pay utilities, the tenant must get the bills from the landlord. Make sure to get a signed copy of the lease to monitor the rules and terms so you can obey them. The tenant must communicate with the landlord about repair issues as soon as they occur. So in other words, you got a toilet that is leaking. You might want to let your landlord know immediately when that happens, because if you wait 3 months and all of a sudden the water bill is sky high, the first thing the landlord is going to say, why didn't you let me know? The tenant must communicate with the landlord about repair issues as soon as they occur. It is best to do this in writing and to keep a copy of this notice. The tenant should return the property to the way it was when they moved in, minus reasonable wear and tear, removing all belongings. So if you paint the walls and they were white when you moved in, you have to paint them back to white when you move out. So if you got a wall that you painted black, don't leave that black wall when you leave there, because that landlord is probably going to have to put 4 coats of paint on that to get that white wall back. Okay, what are the landlord's rights? A landlord can set rules about how the property and common areas can be used. Landlords are entitled to have keys to the property. If tenant changes the locks, they must give landlord a copy. And I have seen situations where a tenant has put an extra deadbolt on the door. Well, if you do that, you got to give the landlord a key to that deadbolt lock. Landlords have the right to evict a tenant using the judicial system. The tenant does not pay rent or do not pay on time consistently or if tenant breaks or breaches agreements in the lease. Some breaches can be repaired. Landlords must pursue evictions through the court system. What does that mean? Back before there was landlord-tenant law, they used to just lock you out and put you out on the street. They can't do that anymore. They cannot use self-help eviction techniques. They have to go through the court system, or else they can be sued themselves. Landlords may require security deposits, and landlords are not responsible for a tenant's personal belongings. What are landlords' responsibilities? Maintain the property in good condition, fit and habitable, safe, sanitary, and accessible as determined by housing codes, repairs completed in a reasonable time, not required to pay for repair damage caused by the tenant. Multi-unit building, landlord is responsible for maintaining common areas. To meet safety and cleanliness standards, a landlord must provide drinkable water in the kitchen and bathroom, functioning bathroom with a toilet and shower and tub, safe and functioning electrical system. We talked about some of those things. No broken locks on doors and windows, accessible and working fire escape, hot water, heat during cold months, no cool air required unless written in the lease, working sewage system, working smoke alarms, and no leaking or roof or broken windows. Landlord's responsibilities continued. A landlord must inform a tenant of lead-based paint in the pipes or the property before a tenant signs a lease. Now, I've been doing this for 29 years. I have never had an issue with respect to lead-based paint. If a tenant tells the landlord that the smoke alarm is broken, the landlord has 72 hours to replace it. A landlord cannot do the following to a tenant: take or sell a tenant's property if they do not pay rent, shut off utilities or lock a tenant out of the property if they do not pay rent, also known as self-help evictions. I just mentioned that. Harass a tenant, what a reasonable person believes is harassment. Enter the property or allow others to enter the property without giving notice, except in an emergency. Remember the example I gave you with the water coming out the door. Require a deposit for an assistance animal, medical, prescription, etc. Cancel an existing lease of the tenants if the building is sold to a new landlord. So if you already have an existing lease and they sell the property, you got 6 months on your lease. That landlord, the new property owner, has to assume that 6 months that was on the old lease. Now, the lease agreement is one of the most important documents in this whole agreement. I've seen a lease agreements that are 27 pages. That's a long lease. And can you imagine being in a property manager's office, getting ready to sign this lease, and it's 27 pages long? And whatever you sign off on, you're responsible for in the four corners of that document. So how long is it going to take to read a 27-page lease? It's going to take you a little bit of a while. And most people, because of that, are not going to read it. They're going to sign it, and there are going to be some terms in that agreement that they may or may not agree to, but they've already signed the lease. A lease is an agreement between a landlord and the tenant that a tenant can occupy and use a property for a certain amount of time in exchange for rent. Be sure to fully understand and agree with its terms before signing. So maybe you need to take that lease home and read it and come back and sign it the next day. Leases can be oral or written. An oral agreement is technically month to month. If the agreement is for more than 4 years, it must be in writing. Now, oral agreements are okay and they're enforceable. But what if the landlord says one thing and you say another? Who is a court supposed to believe? But if it's in writing, it's all there. The lease must be written in plain language. Now, that has been something that they added within the last 10 years or so. Plain language means none of all this legal jargon. The reasonable person, the average person, should be able to understand that lease. If the lease is not clear, then courts are going to err on the side of the tenant. The lease must be written in plain language, no fine print. Once signed, terms cannot be changed unless both parties agree. What can a lease contain? Lease terms: what date is the tenant allowed to live there? When is move-in and move-out date? Repairs: who must make those repairs? Smoke alarms: who is responsible to check the smoke alarms? Visitors: can others stay for an extended amount of time? Limited locations on the property. Now, that's an interesting part right there. What if Cousin Joe comes in from down south and stays about 3 weeks during the summertime? Is that a violation of your lease? I don't know. That's probably something that you may have to clear with your landlord. Entering. Must the landlord provide the tenant notice before entering the property? Yes. When and how and why? If they are entering the property, they must state the date, the time. They must give you 48 hours notice so you can make the decision as to if whether or not you want to be there when they are there. And they have to state why they are there, and they should state when they left and the time that they left. Utilities, who pays for which utilities? You know, some utilities are paid for by the landlord. Some utilities include gas, light, and water. Late charges, are there any late charges? Late charges are another thing. Some late charges are really very high. I've seen late charges as low as $15 and as high as $175. Who's responsible for snow? Who's responsible for the leaves? Who is responsible for the trash? Renewal or termination. Can the lease renew or does it terminate? If month to month, will automatically renew unless the tenant or landlord gives at least 15 days notice before current term ends. Any questions so far? Yes. So when you say went behind everybody's back, what do you mean by that? Yes. So are you on the lease? Okay, you're a certain person, and the landlord was coming in your space without letting you know. That would be a violation. Are you still in that unit? Are you still there? Okay, they can't do that. That's a violation of your lease. They cannot do that. They have to give you 48 hours notice unless there is an emergency. Now, it sounds to me like what was going on is that landlord was selling the property, right? So they probably are trying to get in there in order to get the property ready to be sold, but they can't do that unless it's around your schedule. And you have to agree with what they want to do. Okay, now I'm going to move on and I'll come back if I need to. Beware of fine print, the security deposit. During the first year of the lease, cannot exceed 2 months rent. During the second year of the lease, cannot exceed 1 month's rent. In the third year of the lease, any security deposit over $100 must be in an interest-bearing bank account. Now, we know how much interest these bank accounts are yielding these days. So even if you have money in an interest-bearing bank account, it's not going to be that much. When move out, tenant must provide landlord forwarding address and return the unit to the condition it was found in order to get monies returned. The landlord has 30 days to return it. If any money is deducted, the landlord must provide a written list of the deductions for the actual damages. If itemized list and monies are not returned to the tenant within 30 days, the tenant can sue for twice the amount of money. Be aware of the fine print. If a tenant signs a lease that has this clause, the landlord does not have to give tenant notice of eviction. Instead, the landlord can take direct legal action without telling the tenant. So it looks to me like we might have, okay. We talked about the lead paint. All right. Resolving issues outside of court. I often said that coming to court is next to death. If you can avoid coming to court, particularly for a landlord and tenant matter, there are other forums that you can visit. So when any problem arises, the tenant should send a written notice to the landlord. If the landlord does not respond or does nothing, the tenant should send a second notice. Repairs, take pictures of the damage. Call 311 to file a complaint with the Department of Permits, Licenses, and Inspections. A health and housing code inspector will be sent. Repair and deduct. The tenant makes repairs and deducts costs from the future rent, cannot exceed the monthly rent amount, keeps receipts and estimates, and inform the landlord of this action. Can a neutral third party assist in a resolution? Yes. Before starting a landlord and tenant case, you should decide if the court is the best way to solve the problem. You can solve many problems outside of court using things like mediation, contact just mediation in Pittsburgh, a free, confidential, voluntary process. And during the time period of COVID, Pittsburgh mediation was certainly one of the resources that was used in lieu of coming to court. Early termination of a lease. Tenant has no right to terminate the lease early. Tenant is still responsible for the rent, and the landlord is not obligated to locate a new tenant. In some jurisdictions across the country, the landlord has a duty to mitigate. That means they have to advertise the unit and try to find a tenant to replace the tenant that was already there. In Pennsylvania, I think they've done away with that duty to mitigate. And if you break your lease early, they can charge you each and every month until your lease ends, unless you find a new tenant yourself. The eviction process. What is an eviction? A landlord can decide to evict a tenant for the following reasons. The term of the lease has ended. The tenant has violated conditions in the lease. The tenant has failed to pay rent and illegal activity. Now, those two bottom ones, the tenant has failed to pay rent and illegal activity, are material breaches. The other two are correctable. But a material breach would be something like illegal activity. There was a search warrant on your unit and they found drugs in the unit, and the police were able to testify to that. If your rent's due on the first of the month and you haven't paid it, that's a material breach of your lease. They can bring you to court for that to have you evicted. Notice must be provided before any eviction process can begin. Called the notice to quit or the notice to vacate. Actually, that's what gives me jurisdiction to hear a case. The notice must include the following information: name and address of the tenant's rental unit, the date the notice was served, the reason for the notice, the total amount due, including any late fees, where the payment should be made, and to whom the rent should be paid. If reason is failure to pay rent, tenant has 10 days to pay or leave voluntarily. If reason is any other breach of the lease, tenant has 15 days or to leave voluntarily. Or if it is the end of the lease term, they have 30 days. An ultimatum that the landlord may bring forth a lawsuit for eviction. How is notice provided? Personal delivery or posting the notice on the tenant's door. You can't send a notice certified mail with a signature. That's improper. The notice has to be handed to the tenant personally or posted on the door. And they've even gone a step further for deputy constables. They don't want deputy constables just posting notices on the door. They want them to knock on the door to get an actual person and hand that notice to them. So if a breach or term or expiration for at-will tenants and tenants who have lived in the rental unit for less than 1 year, landlords must provide 15 days written notice. For tenants who have lived in the rental unit for 1 year or more, landlords must provide 30 days written notice. So the notice to quit. In the lease that you sign, and landlord does not have to provide notice. So there are some things, some clauses in leases that are waivers of notice to vacate. So if you sign a lease that has a waiver in it, and that's why you should read that lease, no matter how long it is, see if whether or not you are waiving your right to a notice. That means they don't have to post the door. But I have had instances where there is a waiver of notice in the lease and the landlord posts the door anyway. So I've told the landlord, you've waived the waiver. You posted the door, so we're going to go by what you posted. But if you sign a lease that has a waiver of notice, they don't have to put the 10-day notice on the door. They can bring you straight to court. And some judges, not all, still want to make sure notice is given. But still, no eviction without court order or no self-help evictions. That means you got to come to court if you want to get somebody out of your unit. And it doesn't happen overnight. There's a process. Let's talk about going to court. The landlord wants to evict the tenant. The landlord must sue the tenant or take the tenant to court. and get a court entry of judgment and order of possession, allowing the tenant to be evicted. How does a civil lawsuit work? Between two litigants, the plaintiff and the defendant, determines whether the defendant is liable for injury or harm done to the plaintiff. Plaintiff must have a preponderance of the evidence and has no right to an attorney. What does the preponderance of the evidence mean? It means you got to tip the scales, 51%. You probably heard of beyond a reasonable doubt. That's in a criminal case. That's in a criminal case. But in a civil case, which a landlord-tenant case is, all you got to do is tip the scales at 51%. Who is involved in the landlord and tenant court matters? Judges, like me. Rulings are binding, but may be appealed. I've been appealed many times. Court staff, my staff does not give legal advice, nor should any other court staff, but they can direct the person where to go and enforce court etiquette rules. Lawyers, obviously, particularly in my district, I have districts where rents are as low as $25 and as high as $3,200. Pro se parties, meaning representing themselves without a lawyer, may be able to request or record the proceeding, but they have to request that. Security, those are my deputy constables, can remove unruly individuals from the courtroom. The court is a public area. People are allowed to watch. However, all people are allowed to observe judicial proceedings. All parties should treat each other with respect and with courtesy. Now, when we talk about who can come in and watch a court, now in the Court of Common Pleas, they have courtrooms as big as this room. But in the district courts, some of the courtrooms are small. You can't fit anybody that's in your waiting room that wants to, or anybody that does not have a court action that day to come in and just watch. So it's up to the judge as to whether or not they're going to let that happen. So where's the lawsuit filed? The landlord may sue the tenant either in the local district court, the magisterial district court, where the rental unit is located. Now, they can also sue in the Court of Common Pleas where the rental unit is located if their matter involves more than $12,000. My jurisdictional limit is $12,000. Now, Judge Judy's jurisdictional limit used to be $5,000. So we have one of the highest jurisdictional limits in the country. But if a landlord has a $16,000 back rent issue, they don't want to go downtown because they want to get into one of our courts because they can get their matter heard pretty quickly. They can forego that $4,000 and bring it to our court for $12,000. But if it's over $12,000, and that could be by $1, you have to go down to the court that has jurisdiction over that amount, which is the Common Pleas Court. The complaint. The landlord and/or tenant files a complaint with the magisterial district court where the property is located. There are fees involved with filing the cases. Forms are available at the district courts online, and the website is there. The court may have advocates, interviewers to assist in completing the necessary forms, but this is not legal advice. Every complaint must include your name and address, the amount for which you are suing, and a short statement explaining why you are suing. Every county has different rules. Check your local rules and websites. The service of the complaint and the response. The complaint may be served by a court officer in first-class mail to the last known address and posted on the rental unit. So there's two forms of service. Send it first-class mail, and they send a deputy constable out to post the door. The complaint explains that the defendant should respond to it. The court provides a date for a hearing, generally 7 to 10 days after service. Now, why is that such a fast turnaround? It used to be years ago that it could be over a month before you got somebody to court, and they could be messing up your unit. They could be not paying. You may have a mortgage on that property, and you got to pay the bank. So they have narrowed that down to that after you file the case, you're going to get a hearing within 7 to 10 days. If a tenant has a claim against a landlord arising out of the occupancy of the premises, which is within the magisterial district judge's jurisdiction, and in which the tenant intends to assert at the hearing, it must be filed on the complaint form before the time set for the hearing. So if the landlord is suing you and you're suing the landlord has to have knowledge of that and has to have proper time in order to defend that matter. This could be because the tenant wants to sue the landlord at the same hearing for any expenses such as back rent and repairs, and it makes sense. Why file two separate cases and they have to come back? Let's do all this at the same time. What happens next after the complaint is filed? The complaint must be served on the defendant with a notice to the defendant. The court will set a hearing date, which can be a trial date. If defendant does not show up, the court may enter a judgment against the absent party for possession and costs, as well as damages and rent. Tenant could also be evicted. If plaintiff does not show up, the court may dismiss the case. The defendant can request a continuance to move the trial date back, and the court may grant such continuances if justice so requires. This request should be made in a written document or motion filed at least 10 days before the hearing date. Defendant should file a response or an answer to the complaint and must file a complaint if there is a claim against the landlord. Notice to the occupant. Okay. New rule for occupant who may not be a tenant. Now, I'm going to judge school in about 2 weeks. If this is the new rule, I haven't gotten it yet, and I'll get it when I go to judge school. However, the occupant, this is for, I guess, other occupants that are in a unit, but you're suing the person who is on the lease, but you know that there are other people there. So, new rule for occupant who may not be a tenant. Occupant could be evicted, so now permitted to file a motion for intervention with the magisterial district judge's office at any time before the hearing. If the occupant has a claim against the landlord, the occupant must file it on a complaint form at the same time as the intervention request. I'm not familiar with what an intervention request is, but it is a new rule. I will be getting that information in the next couple of weeks. What a landlord should bring to support their case: the written lease. You'll be surprised how often I see a landlord come into court. They sit on the left side and I see nothing in their hands. Absolutely nothing. And then I see some landlords come in and they have all these documents, and it kind of gets me mentally prepared for what I may have to deal with. A housing inspection license if operating a multi-unit building. I'll be honest with you, if I've seen one of those, I can't remember it. A copy of the notice to quit. I always want to see that. And so do any lawyers in the courtroom want to see the notice to quit, unless the lease waives the notice. Unpaid utility bills, if the lease requires a tenant to pay them. Photographs of alleged damages, very important. Proof of payment, invoices, and estimates. So if the landlord had to go fix something that the tenant broke, they should bring that bill with them. Communications between the parties about any damages. And when in doubt, bring everything with you. What a tenant or occupant should bring to support their case: to sue for repairs, habitability, running water, they should bring the written lease. I don't recall seeing a tenant bring a lease to court, and the landlord has a lease on the other side. Pictures of the conditions, notices to the landlord of the conditions. To sue for a security deposit. They want the written lease, documentation that the keys were returned and a forwarding address were provided. I've seen many situations where the tenant just leaves, doesn't even leave the keys. They still have the keys in their pocket, and they may have left a chair or a toothbrush or something like that. That may be an indication that you are still in the unit. Documentation that the key was returned and the forwarding address was provided. Documents from the tenant to the landlord demanding the return of the security deposit. When in doubt, again, bring everything with you. What happens at trial? Make sure you bring all your documents and have witnesses ready. The judge will explain the procedures. The party filing the complaint presents the case first. Sometimes the defendant sits down and just wants to start talking. The opposing party and judge are permitted to ask questions. After all facts are presented and the judge has asked all their questions, the judge may decide the matter at the conclusion of the hearing or send the decision out within 3 days. Landlord-tenant cases have to be decided within 3 days after the hearing and before the entry of judgment. The order for possession. Now, assuming the landlord has won their case. If a judgment is entered in favor of the landlord still cannot evict the tenant by themselves. The landlord must wait 10 days after entry of judgment and then ask the court to issue an order of possession. So the 10-day period is the 10-day appeal period that the tenant gets after the judgment has been rendered against them. If they file an appeal within that 10-day period, then it goes downtown to the Court of Common Pleas, and it is a de novo hearing, meaning it is brand new. If the tenant does not file an appeal, the court will serve the order of possession by mail, at least to the last known address. And the sheriff, and when you hear the word sheriff, it could also be constable, will serve the tenant personally or by posting it conspicuously at the leased property. And what are the reasons why they want the constables to make a contact with the person? Let's suppose it's a big apartment building and it's locked and they can't get in. And they're posting the notice for the tenant in a 50-unit building on the outside door, because they couldn't get into the tenant's door, so they're posting it on the outside door. So the courts are demanding that constables take an extra step in order to serve the defendants in these cases. Now, after the 10 days, if the tenant remains in the unit, on the 11th day, the tenant can be forcibly evicted. Now, what that means is that after the 10-day appeal period is over, once the order for possession has been filed, 11 days after that, they can change the locks on the door. If the tenant is forcibly evicted and leaves possession behind, the landlord must notify the tenant by first-class mail to retrieve their property. So they're evicted and all their stuff's inside there. What can the landlord do? Well, they can store it somewhere and charge the tenant storage fees, or they may be able to dispose of the property, but you want to give the tenant notice before you do that, and you want to protect yourself. The law is not clear as to how long you should keep someone's property in your unit, but let's suppose this person has high-end good stuff. There's $20,000 worth of furniture in there, and you just evicted them. I mean, are you really going to put that stuff out on the street? You know, probably not. And what if it's not $20,000 worth of stuff? What if it's something less, but it has no value to you, but it does have value to the person that used to live there? So you would probably be better off storing those items somewhere, charging them storage and giving them a certain amount of time, sending a letter to the last known address, because you may not have a forwarding address for that person, and in hopes that they would get that information to let them know that if they don't pick their items up by a certain day or a certain time, that they will be disposed of. So if the tenant is forcibly evicted and leaves possessions behind, the landlord must notify the tenant by the first-class mail of the right to retrieve their property. The tenant has 10 days from the date of notice to retrieve possessions of the landlord to store for up to 30 days. If the landlord stores possessions, tenant will be responsible for the cost. If tenant doesn't retrieve the property, the landlord can dispose of it. Now again, 30 days to me is enough time to cover yourself if you have to dispose of someone's property. Let's suppose you do it within 2 days. Is that reasonable? That may not be reasonable, but 30 days does sound reasonable to me. Obtaining a stay of eviction. If a judge has entered a judgment against a tenant must file a notice of appeal within 10 days to pause an eviction. If tenant is a victim of domestic violence, the tenant has 30 days to appeal and file a domestic violence affidavit. If a tenant does this, the tenant must deposit with the court either 3 months rent or the amount judge ordered to pay, or whichever is less. Meaning, if your rent's $1,000 a month and you have a $6,000 back rent judgment against you, in order to appeal that case, you're going to have to come up with 3 months rent or $3,000, or the judgment amount, whichever is less. Well, the $6,000 will be more than the $3,000, so you don't have to come up with that, but you have to come up with at least $3,000, unless you are a low-income tenant and you cannot afford to pay that amount of rent. So if a tenant is a low-income tenant, they may qualify for an informal pauperous waiver, meaning this waiver will allow the tenant to pay only 1/3 of the monthly rent into an escrow account. The other 2/3 will be made payable within 20 days. So going back to the $1,000 a month rent example, if that person cannot afford to file the appeal and they qualify based on informal pauperous status, they're not going to make that person pay the $3,000 in order to appeal their case. They're going to put them on a percentage of that, or a payment plan, and they're going to give them a date by which they have to make those payments in order to keep their appeal alive. Appealing a decision. If a landlord or tenant wants to appeal a decision, they must first file a complaint with the Court of Common Pleas. If an order for possession was issued, an appeal must be filed within 10 days. If a money judgment is entered, an appeal must be filed within 30 days. So there are two forms of an appeal in the landlord-tenant case. 10 days appeals to possession, the part where they can put you out, and 30 days to appeal the money. But let's suppose that you just leave within that 10-day period, but you have a disagreement about how much money you owe the landlord. You can still appeal the money even though you're no longer in the unit. And there are some websites, landlord-tenant laws in Pennsylvania. They're up here on your screen. If you get a copy of this presentation, you'll have access to the websites. And that is it. Any questions?